Hello, everyone. On behalf of Rogers Capital Tax, I would like to welcome you all to the live webinar of the Tiger Global case, Implications for Mauritius as an International Financial Center. I am Shafinaz Ramgulam, Head of Advisory at Rogers Capital Tax. The Supreme Court of India has delivered a landmark judgment in the case of the Authority for Advanced Ruling Income Tax against Tiger Global Investments, with wide implications for global tax and investment structures. Under the long-standing double taxation avoidance agreement between Mauritius and India, companies resident in Mauritius have been claiming exemption from Indian capital gains tax on grandfathered investments. In the Tiger Global case, the Mauritius Tiger Global entities, which are global business companies, had invested in Flipkart Singapore, which in turn held and derived substantial value from Indian assets. The Mauritius Tiger entities had valid tax residency certificates, and their investments were grandfathered, being acquired prior to 1st of April 2017. As part of Walmart's global acquisition of Flipkart, the Mauritius Tiger entities disposed of their shares in Flipkart Singapore to a Luxembourg buyer and derived substantial capital gains. In that case, the tax authorities, denied treaty exemption, and this ultimately went to the Supreme Court. The Supreme Court in this case sided with the tax authorities, saying that a tax residency certificate is not conclusive. Rather, it creates a rebuttable presumption, which means that the tax authorities can look behind a tax residency certificate to see where real control and substance actually sits. The Supreme Court has also made mention of effective control and ruled that the companies are seen as conduit companies with no economic commercial substance. So today, we will unpack not just the legal outcome, but what it means for investors, advisors, policymakers, as well as the future of Mauritius as an IFC. I am honored to have with me today a distinguished panel of experts with deep experience across international tax, treaty interpretation, fund structuring, and investment governance. First of all, we have Afsar Ibrahim, co-founding partner of KIC Advisory Services with over 25 years of experience in the international business and corporate sectors. KIC Advisory has its partner in India, targeting India outbound investments into Africa. We have Iqbal Rajabali, senior counsel at Ivy Chambers, former chief executive of the Financial Services Commission, and notably the initiator of the 1994 Certificate of Tax Residence System. We have Ryan Alas, Managing Director of Rogers Capital Tax, a well-known tax litigator with deep expertise in international taxation and double taxation avoidance agreements. He holds a postgraduate in international taxation issued by the Royal Society of Fellows, USA. And we have Joanne Haig, Managing Partner, CMS Prism, a former English solicitor and Magic Circle lawyer, and Mauritius tax barrister. She represents taxpayers on disputes against the MRA before all courts. And finally, joining us from India is Mr. Pramod Kumar, former Vice President of the Indian Income Tax Appellate Tribunal. With over 22 years as a tax judge, he currently serves on the United Nations International Tax Committee subcommittee. Thank you, panelists, for joining us today.
Thank you.
Thank you. So first of all, to start, thank you, Pramod. So first of all, to start this discussion, perhaps it will be best if we could hear from Pramod, first of all, to understand about this judgment. What would constitute, according to you, Pramod, the binding ratio decidendi of the Supreme Court, and which observation would be properly treated as obiter dicta?
Thank you so much for inviting me to be a part of this panel discussion. Now, what constitutes everything that is said by a judge is not necessarily the binding precedent. And to decide, the only thing which in a decision is binding is what constitutes ratio decidendi, and certainly not the obiter dicta. Now the question really is, how do we isolate ratio from obiter? And a division bench of the Honorable Supreme Court in April 2023, that is the last judgment, and a very short judgment, when they were beautifully explained which portion of the judgment constitutes binding law and which is not. Now, they recommended something called inversion test, and that's again from an old judgment of the Honorable Supreme Court itself in the case of the State of Gujarat versus Utility Welfare Association. This is a very simple test. All it says is that to isolate a ratio decidendi from the observations, the proposition is to be inversed. That is, removed from the text of the judgment as if it did not exist. If the conclusion of the case would still be the same without examining this proposition, then it cannot be regarded as ratio decidendi of the case. Now, in the light of this fundamental legal position, please consider what was the question for the consideration or the adjudication by the Honorable Supreme Court. And the question really was whether or not authority for advance ruling was justified in rejecting to give a ruling in this case on the ground that prima facie, that is on the face of it, it's a tax avoidance arrangement. And then their lordships went at length in paragraph 34, 35 to explain what is the meaning of prima facie. They said it is not to be conclusive. So the conclusion was that because on the facts of this case, it appears to be subject to further examination, a case of tax avoidance arrangement. Therefore, this is a matter which should not have been adjudicated by the authority for advance ruling, and authority for advance ruling rightly did that. Now, that was a core question. And when you say that this is a call taken by the Supreme Court on merits, on the question of what is right, what is wrong, I would beg to differ. I would say that they have made some observations which are not in the nature of a decision, but which are an arbiter in the process of coming to the conclusion as to whether or not the authority for advance ruling was right in declining to entertain the application. And please also understand, what is the status of the case today? Today, matter is back before the assessing officer. So everything is to be examined on merits. It is not the final word. Final word is only on the short question, and that question was whether the authority for advance ruling rightly rejected it. And it became relevant in the context that when the matter had traveled to Delhi High Court not only decided against the authority for advance ruling, but they also gave an adjudication on merits, which stands vacated. So today you are back to the fundamental position where everything is to be examined by the assessing officer. And that's the reason sometimes I feel that the apprehensions are much more on account of some interpretation rather than the judgment itself. Judgment has been very straightforward and candid in saying that these are our prima facie observations. Everything is to be put to test. So I would think from the point of view of the taxpayers, there's no reason to panic as of now. There may be some observations, but those are in the nature of arbiter.
Okay. Then in that case, Pramod, if we are talking about the judgment of Tiger Global, what will be the main issues and what would you consider as being issues which has been mentioned by the Supreme Court, but does not lead to the conclusion what has been reached in that case?
All right. So the main issue to my mind, as I said, first issue was whether AR rightly rejected or not. And to decide that issue, what was also to be decided was whether a TRC simpliciter could be a license to the treaty entitlement. What the Honorable Supreme Court has said is that in the post-GAR situation, just because you have a tax residency certificate, that itself is not sufficient for treaty entitlement. And the GAR provisions, the General Anti-Avoidance Rule provisions, would override treaty provisions to that extent. So if you ask me the legal position about whether the TRC simpliciter is entitlement for the treaty benefits, answer is no. The reason that is because of the GAR. And I would go a step further. I would say post GAR, even if you are treated as a resident, but it can be demonstrated that here is a tax-driven transaction and it has one of the tainted element, for example, the lack of commercial substance, then that effect of the arrangement is to be ignored anyway. So it does not really make a difference. The impact of the GAR provisions on the treaty was the critical part, but that is in most parts of the world, GAR overrides the tax treaties. Now, another question which came up and which I would think is not really very relevant from the point of view of ratio is the treaty protection which was sought on the indirect transfers in the context of 13.3a. Now, here is a case which the taxpayer has taken different stands at different points. Please understand what was Tiger Global's case for treaty protection. Tiger Global's case was that I have made investments in a Singapore company, which in turn had underlying assets in India, but nevertheless, I'm protected by the exclusion clause of Article 13.3a. Now, Article 13.3a says that if you have made investments in Indian companies post the cutoff date, then for that you have to pay the taxes. Now, the relevance of cutoff date is that if you make investment prior to 1/4/17, they are protected. If you make investment post 1/4/17, they are not protected. But that is with respect to the companies' shares in the companies which are resident in India. Interestingly, in this case, even though the shares were in the company which was resident in Singapore and had underlying assets in India, the claim of the Tiger Global was that I'm covered by exclusion in 13.3a. Court said, no, you are not, because you don't hold shares in an Indian company.
Okay.
And that's perfectly valid.
Yes.
You would rather go in 13.4.
Yeah. And we will come to that, Pramod. I think the indirect share transfer is something that is very important, and we will cover it, as well as we will go in more detail about the GAR provisions as well at a later stage. Before we come to substance and the commercial rationale for having a company in Mauritius, let's go to Iqbal, who can explain to us a little bit about the tax residency certificate, about how it has evolved and how pertinent it is for cross-border transactions with Mauritius.
Well, thanks again for having me in this distinguished panel. And the topic is extremely interesting. And it's extremely difficult as well to understand this particular judgment because of the intricacies of the procedural traveling that it has done from the assessment officer right up to the Supreme Court. Yeah. Anyway, to get back to what's interesting about this judgment, it's almost like a history book. And it has got a layer of political insight into this whole system of cross-border investment. And it describes very well the position, the policy decisions of governments in treating foreign investment. Mm-hmm. And it starts from 82, as he said, as the judgment said itself, but rather put it in the way from the point of view of the Indian government, saying that all those structures from Mauritius started in 80. It's not true. In fact, the treaty was signed after the visit of Srimati Indira Gandhi to Mauritius in 1983 or 1982-83. And subsequent to that, the treaty was signed, especially to favor Indian state companies to set up in Mauritius. And one of those entities are still in Mauritius. It is the Life Insurance of India. But it is rightly pointed out in the judgment that the actual trigger that gave a momentum to the use of this DTA has been this coincidence in time when young Rajiv Gandhi took up prime ministership in India and opened the Indian economy. Mm-hmm. which till then was very much a closed-in socialist republic tied up under the wings of the Soviet Union. So when he opened up the economy and there was this Mauritian route to India, it brought in a great disturbance within the professional or financial structures of India itself. And so there was a tug of war between the well-established financial advisors in India and the new entrants coming through Mauritius. And so it created a lot of tension from the business community of India, which crept up into the ranks of the bureaucracy of India. And so we had to face this issue about how the Indian government or the Indian Revenue Authority was going to treat structures from Mauritius into India under the treaty. And we had, on the other hand, the problem of investors from outside the region, Europe and America in particular, having seeing a newcomer on the block. And we had to win their trust to get their business in. And to do that, business people look after certainty, and that has been throughout centuries, and it will continue to be. And how to develop that trust, it is not my word or the word of our Prime Minister then that mattered, but it was like substantive right granted and given. They must see the paper which evidences what they are putting the stakes on. So after a few discussions with the Indian authorities, we decided to issue this certificate of residence, of tax residence in Mauritius. Remember, in those days, it was pretty simple. International taxation was a simple matter. You just have to know which jurisdiction had the lowest rate of tax, and does it allow capital flow in and out, and that makes you a great international tax expert. As basic as that. So residence in its formalistic sense was pretty well defined, as we saw it at that time, under the treaty. So we just made a statement that correspond with the Article 4 of the DTA to reflect the commitment of the government and the backing of the government against the treaty promises. And that was accepted, and you would recall, and I think it is mentioned in the judgment as well of Tiger Global, that the first circular issued by CBDT in India was in '94, reassuring people of the value of the tax certificates. That is, you go along the tax, in the Mauritius issued tax certificate was enough to give you the status of resident and therefore entitled to the benefits of the treaty. Why was that? It was because of the rumblings as well within the government, within the Indian society. And then you would see throughout the history, and perhaps it rolls over up to now, we had a good understanding. Myself, I met the Prime Minister, the Finance Minister of India, Dr. Manmohan Singh at that time, and from the government point of view and the Mauritian government point of view, there was great consistency in approach, and everybody understood that India opening up to the world market meant that Mauritius was a valid, valuable, and useful channel for foreign investment into India. So we were favored by the top government cadres, but within the bureaucracy, there were a lot of resistance to the change. So it went on, this aggravation, this little tension, and we had a lot of challenges which were being discussed. And then we came up in 2000 with the new circular that reassured investors about their existence of, well, the status of residence. You would remember this is the time which coincides with the OECD Global Tax Forum against harmful taxation, harmful competition. Yeah. And so that again, in which the government officials were participating strongly in that global forum of OECD to try to bring forward the issue of two issues mainly. One is the NRIs, because they were quite concerned about the non-resident Indians coming back to India. And then linked to it was the other idea of the round-tripping.
Yeah.
That is, businesses in India going round to the NRIs and back into India. And there was this concept which was the OCBs, what is it now? Overseas Corporate Businesses, I think it was. So that was in the mind of the assessment officers, which made a lot of challenges to. And then came the first major judgment that clinched at that time their issue, which is the Azadi Bachao, which made it very clear that the certificate has a particular value, which is to validate the residence.
Yes.
Then came further. Mauritius started to get on the books, and that's an interesting aspect of it, is that the Mauritius-India Treaty is a textbook lesson, which now is the main focus about Mauritius, a jurisdiction, used as a stepping stone, as they would call it. And there were those studies brought out by the OECD about those see-through jurisdictions like Mauritius. And Vodafone came up. Complex case, but interesting judgment, which mainly re-established the force of the certificate.
Yep.
But the sea change came between 2013 or so, or 2012 rather, till 2016. Between that, the pressure from India increased enormously. There were frequent delegations from India coming to Mauritius to challenge the use of third-party countries or citizens from third parties using Mauritius as a conduit. And so that became under heavy pressure. There were a number of changes in the tax laws in India, and also circulars around it as well. And then the coup de massue was the change in the DTA, the protocol amending the DTA. And what is the cumulative effect of it? It is that it throws back into issue the status of the residency certificate, the tax residence certificate. And it allowed challenge under the GAR, the new enactment of GAR under the Indian income tax law. I think it is section 92 onward, where the GAR would allow, on a prima facie view, investigation that goes beyond the tax residence. So you've got the status, I'm just summing up on that, the status of the certificate as such. There is also the question of shell companies and conduit companies, which is mentioned in the GAR, and the circulars explaining the GAR. And thirdly, it also allows it focus essentially on capital gains. And if anything else, the Mauritius-India Treaty, basic fulcrum is the capital gains. That's the main advantage of it.
Yeah.
So this is how this judgment, I think, goes to demonstrate that over time, the landscape, the international landscape, I would say, not only India, Mauritius, but the international landscape has changed focus from the pure formal aspect of residence to something which is wider than that. And the idea is to avoid the problems of conduit countries.
Yeah. Because after we have had Azadi Bachao case, Vodafone case, there was a comfort. But then, so the Tiger Global case which came, the ruling which came, it's not something that is happening right now. It has been coming for a while. And we finally saw it in the judgment.
The signs
now,
were on the wall.
Exactly.
And I think it's the culmination
Yes.
of all the apprehension.
Yeah.
And like good
Finally.
ostriches, we just dug our head in the sand and pretend
Haven't
nothing
seen,
was
yeah.
happening, and we did nothing.
Exactly, because it's something that was about to happen. We just had to wait for it.
And that's why the
happened.
spillover effect of that judgment is larger than we may think.
Yeah. But then, if we are talking about, as we have said, the TRC perhaps would not be a conclusive evidence, as has been said in the Tiger Global case. As at now, like we have been treating it as claiming treaty benefits with that TRC. Maybe your perspective, Ryan, under the treaty, we have been using that TRC for a while now. What is your view on that, and how it will what will happen now going forward?
Yeah, and in fact, I think up to now, taxpayers had legitimate expectation to rely on the circular, the
Yes.
789 circular, issued by the Indian authorities, which was challenged in I think the Delhi High Court, and the state of India itself challenged the decision of the Delhi High Court, and the Supreme Court confirmed that the validity of the circular. This was before Azadi Bachao, and which means that the state itself was in agreement that TRC is valid.
Yeah.
And of course, like Iqbal has said, the international taxation has changed drastically. Now there are so many things happening, BEPS 1, BEPS 2, there would be global minimum tax, etc. So, but despite all this, taxpayers need certainty. They need certainty, and in terms of treaty shopping, the judgment I know talk about treaty shopping. We must take into consideration, I think, that this is not included in the treaty. There are treaties where specifically it is provided that for a resident to benefit from the treaty, you need to have, let's say, 50% shares, for example, owned by physical persons from that country. This does not appear in the treaty within, even the new protocol that has been discussed, which is not yet in force. And one thing which is important as well is that until now, because the new protocol is not yet in force, the protocol, the convention between Mauritius and India, the introductory report, it mentions that it is an agreement for the avoidance of double taxation, prevention of fiscal evasion with respect to taxes on income and capital gains, and encouragement of mutual trade and investment. This is still there. So if there was an investment which was made before the amendment of the treaty, that was for the encouragement of mutual trade and investment, then it is as per the objective of the treaty. It's under the new protocol that we talk about. It should exclude transactions which are aimed to cause non-taxation, etc. So I don't know if the Supreme Court is already, with all due respect, they are already taking the protocol as being enforced. And second thing that I wanted to highlight is that under the treaty, we have a specific, like Iqbal said, Article 4 provide for specific conditions for a company to be treated as resident in each of the contracting states, to be eligible. And the residency criteria for each state is defined by the contracting law, or the laws of Mauritius. And the judgment also referred to the conditions in the Financial Services Act about control and management. But I think those persons who are best placed to know if the companies incorporated in Mauritius are meeting these requirements would be the Mauritian authorities. And in case of dual residency, of course, then India could challenge, and we can, if India is saying that the company is also resident in India, then it is a case of dual resident, and it will be where the effective management is.
Yes.
But under our domestic law, there is no concept of effective management. And having heard Pramod earlier that this is only one part of the procedure, I don't know if the options that can be available to Tiger Global as well is under Article 25 of the tax treaty between Mauritius and India. There is mutual agreement procedure.
Yes.
Maybe instead of going to the AAR or to the tax authority of India directly, they can go also to the tax authority of Mauritius to engage discussions with India, with the tax authorities in India, to come to a mutual agreement between both authorities where the company is incorporated, where is resident.
Is resident. Yeah. Okay. In fact, Brian has also mentioned about the conditions, what are the requirements. And in that case, I will turn to Rohan, because I think Iqbal has mentioned as well, what are the conditions in fact? What are we looking at when we are giving a tax residency certificate? We have the substance requirements as per the Financial Services Act, and we have other substance requirements which falls under the Income Tax Act, which is specific. So how do we give a tax residency certificate, and what is the criteria in Mauritius?
Thank you, Shafinaz, for that question. It's a very valid question, and it's a source of daily confusion and frustration in my daily practice, because I think a lot of people necessarily assume that control and management is as per the FSA definition, which may not necessarily be the case, but in practice, that's something different happens. So I think very briefly, if I could just explain how under the Income Tax Act we define residence. So prior to the OECD-related changes, we had two ways in which a company could be treated as resident under our domestic laws in Mauritius. As Ryan rightly pointed out, under the treaty, it refers to the domestic laws of the other contracting state, which in this case was Mauritius. So prior to 2018 changes, it was either by way of incorporation or central control and management. And then post BEPS changes, we have switched to central control and management only. Practically, that is the definition of tax resident in Mauritius. Now, the Income Tax Act does not actually have a definition of central control and management. But typically, a tax expert would apply international or, in the case of Mauritius, Commonwealth tax law to define where central control and management is, which is typically where the highest level of decision-making takes place, usually but not always at the level of the board. Now, that is the tax definition, as I understand it, as we understand it, of central control and management for tax purposes. Now, the slight disconnect is that in Mauritius, under the FSA, in order for a GBL to be granted a license, it needs to have its central control and management in Mauritius for regulatory purposes. And there's a few factors that the FSC would look at to ensure that is indeed the case, which includes, we all know them by heart, we put them, not we, the management companies put them in their marketing materials, 2 resident directors, the accounts might be audited in Mauritius, board meetings chaired in Mauritius, etc. There's about 5 factors. Now, in practice, what was happening is that the Revenue Authority was looking to the FSC for comfort that the CMC conditions were satisfied for regulatory purposes in order to issue the TRC. So in my view, there was always this sort of disconnect between what we understand CMC to be for GBC companies and what I would say is the international best practices for tax purposes of what CMC actually is.
Yes.
So I think I will have to agree with Iqbal that the writing was on the wall. It was a question of when and not if. Could the Tiger Global judgment conclusion been avoided if our definition of CMC for tax purposes was clearer and more aligned with international best tax practices? I don't know. I don't have the answer. But certainly, I think it would have gone a long way in perhaps not avoiding, but mitigating the effect of what we're seeing. From a tax point of view, having audited accounts done in Mauritius, I'm not sure how that goes to show that the highest level of decision making is taking place. So there's always this tension, and I'm sure we're going to cover that later on today, but should we be seeing it as an opportunity to revamp decide, how we issue TLCs, not just for GBCs, but for, we're supposed not to have ring fencing anymore, right, for tax purposes, but for all companies, resident in Mauritius.
Yeah. And we will come to substance later, because we need to talk about substance definitely, and the 5 conditions definitely would not be sufficient. I remember the FSC had issued guidelines before on additional substance, etc., repealed and everything. So something to discuss later.
Having arbitration in Mauritius was one of them. I remember.
Arbitration in Mauritius, etc. So we had that, and it was repealed. So
if I may add, there is a pretty harsh comment by the leading judge in this judgment about the content of the tax certificate issued by Mauritius.
Yeah.
It's almost like it's saying, like, it's a
nothing
piece
in
of paper for the dustbin.
Yeah.
In a sense, it was so irrelevant
yes,
to the whole discussion that was taking place about
the tax residency certificate.
Exactly.
But then, Afsar, I have to ask you your opinion on the tax residency certificate to round everything that everybody have been saying.
Thanks for having me here. For me, anything that will disrupt the status quo, I'm all for it. And I think this judgment come at the right time, in a sense that it has disrupted what we have always been doing. That's welcoming in itself. And when the law changed, like Iqbal said, we chose to look the other way. At least now we have a clear roadmap, assuming this judgment is valid and going forward. Clear roadmap that gives Mauritius the opportunity to up our game.
Yeah.
I don't see this judgment as against Mauritius. I think it's a judgment against any IFC who are going to use multiple structures to go into India.
Yes.
Apart from talking about TRC, I think this judgment is saying to the IFC, if you're going to be a low-value service provider to investors into India, we don't want you. I think that's the message is very clear.
Yes.
And that's where we need to refocus ourselves and look at our value offerings and make sure that we go up the value chain. If we are going to go like we have been doing, then we'll have to, the door will be closed.
Yes, of course. Yeah. But then if we are to talk about the issue of upping the game, of becoming a better IFC in terms of the new economic situation and the international landscape now that we have. So we will need to talk about substance again. We will need to think about what do we actually mean by substance. And the judgment has talked about commercial substance a lot. So in that case, I will still come to you, Afsar, to talk about if the Supreme Court is saying that the TRC is not conclusive, and Tiger Global is saying that they have a commercial rationale and they do have 2 employees, etc. They have, and they meet the conditions of Joanne. We will not focus on that, but they have commercial.
They are not my conditions.
But then, what do commercial substance mean in practice for you, for companies claiming treaty benefits?
Just before I answer this question, I just would like to finish off on one thing that crossed my mind.
Yeah.
This judgment, which is against all IFC, is also going to create a precedent for all other countries to look at
I
us
agree.
in the same way.
I agree.
So we have been talking about taxing rights from Africa, how we share it. I think this will be on the table. So we can't this time round turn away and say it will be business as usual.
Yeah.
Talking about commercial substance, I'll give you a simple example, which we had in Mauritius. I think Iqbal also is familiar with this. In 1993, there was an Indian company called Essar that came to Mauritius and bought a textile mill here called Consolidated Fabrics. We were involved at the time with the DCDM, and this was one of the transactions that happened. Since then, Essar today has got a huge premises in Port Louis, opposite the restaurant Champ de Mars, exactly like they have their building in India opposite Mahalakshmi, where today all their investment decision globally is taken.
Yeah.
This is not about investment decision in India, but globally. This happened many years ago, and it's probably the only Indian company in Mauritius with that level of substance. If we want to up our game, we need to allow all those investors who are going to use Mauritius to open their offices, to buy buildings in Mauritius in a very simple manner, to bring their executives to Mauritius, not paying the fair share contribution, but making it very attractive for all the parties concerned. I think we have a very nice card to play. I think this judgment is a watershed moment, but it could be a blessing for the next phase of Mauritius. Let's not forget that DTA, which Iqbal was giving us the history, was set up for India outbound. And then it, by I think the genius of a couple of lawyers, it ended up being an inbound treaty. But these days, the India we knew then and the India today is not the same. And we cannot be using what we used to do to handle India. India doesn't need us. We need India. So we always look at them. It's time to look at us and see how we are going to raise the game and going to offer India a value proposition that makes sense to them and makes sense to us, and also will make sense to other African countries as well.
Yeah.
That we are an IFC of substance and repute,
Yeah.
and not an IFC of issuing just a piece of paper, just getting the audit done in Mauritius, and you said, I've got 2 directors, and that's it.
Yeah. Yes. So we're talking about having definitely people, the infrastructure and everything. But
Everything.
it goes beyond that to
Beyond that.
decision making, to taking the actual decisions here in Mauritius.
You see, the mistake we have made over the years is we have looked at financial services in Mauritius to be only global business. Financial services is much wider, and it integrates your hospitality sector, your property sector, your all other aspects of the economy. The day we realize that financial services integrates all aspects of the Mauritian economy, we'll think differently and we'll stop just thinking about TRC.
Yeah, yeah. And also, why the problem is sometimes like there are certain substance conditions in the income tax regulations, but it only relates to when you want to claim the tax exemption. So it doesn't. It's not applicable to all companies, like multiple times, etc., rubber stamping and everything.
You know, we got
It's
to look
not-
beyond that. These are micromanagement, ticking the box. I mean, I don't want Mauritius to be an IFC where you tick the box. Leave that to Labuan or stuff like this. You know, if we are going to be
Yeah.
one which is going to have substance, we have to up our game across the industry sector
Yeah.
and make Mauritius an IFC where you can come and raise your capital here. Indian companies today can't raise dollars for their overseas expansion. Make Mauritius the capital. We are talking more than just substance here.
Yeah.
It's a new value proposition that we need.
And the cost will definitely not be that big compared to what you will get in return. in
Exactly.
terms
We have
of
to look at the
savings
broader
and
stuff,
everything. Yeah.
and that's where we need to increase our value proposition.
Yeah. Okay. And in that case, when we're talking about substance, and we have mentioned GAR as well, and GAR provisions has made specific mention of tax avoidance. They have talked about why GAL came into play, because it was seen as being an impermissible avoidance. I will ask Ryan about tax avoidance, because on the basis of, we are talking about effective management, etc., being outside of Mauritius, and that's undermining the commercial rationale of the companies being in Mauritius. And I've already explained that commercial rationale we need to see beyond what we are currently doing right now. So how do you separate acceptable tax planning and what is considered as being tax avoidance? Yeah. How do we make that difference?
Yeah, Shafinaz, maybe before we go on into this, I would make a comment, maybe Pramod or anyone else can comment afterwards. There is something that for me is still not clear in the judgment. There are two statements which appears to be contradictory. First, the Supreme Court is saying that the company is not entitled to treaty benefit because it's an indirect transfer.
Yes.
Yeah. If that's an indirect transfer, so it's the end of the game here. But then it says also it's not entitled to treaty benefit because it's a tax avoidance scheme. So it's either or. If it's a tax avoidance scheme, then you meet the conditions to qualify. Indirect transfer can benefit from tax treaty, but because it's a tax avoidance scheme,
it cannot. Yeah.
Or it's not applicable at all. So then you don't ever need to look at whether it is a tax avoidance scheme or not. Yeah. So just regarding your question on tax avoidance, it's not illegal. It's permissible, but it needs to have substance behind it. With the principal purpose test that is in the new protocol as well, is that it means that you can structure your transaction in a tax efficient way. But this should not be the main reason. Before it was the principal, one of the main reason. Now it should not be one of the main reasons.
Yep.
So as long as you can justify that, for example, for Mauritius, for an SPV with one specific investment, what type of substance level they can be in Mauritius to justify that there is a commercial rationale? Maybe it's because of we always talk about it, but we don't. I don't think we highlight it enough. Is that Mauritius is a politically stable country. This is one reason that can justify why someone is choosing Mauritius. There is a tax factor as well, but the main reason is you are not going elsewhere because Mauritius has a good reputation as well. Why don't you go to other jurisdictions which are blacklisted, etc.?
Yes.
And with Pillar 1 and BEPS 1.0, BEPS 2.0, now it's clear that substance is core. Substance is very important, and in any case, taxation rights now is based on where the economic activities is being carried out. In this judgment, it makes reference to the fact that there are some decisions that couldn't be made by directors in Mauritius. So we should ensure that directors in Mauritius has the power to take decision. They should not be mere rubber stamp. Maybe there should be a limit on the number of boards that a director can sit. If there is a director who sits on 300 board, then in another judgment in India, mention was made of it. But how does it have time to exercise due care in the board? So I agree with Afzal that we should build more substance. We should have a different value proposition. But I think this is something that will come with time. But in the meantime, we should, step by step, this judgment is a wake-up call for everyone, for every directors as well who sits on the board of AGBL. Do I have time to do the job that I'm requested properly?
Yes.
Am I just a rubber stamp? Specifically, given that the risks that they take for being on the board, that they are personally liable for Mauritius tax.
Definitely, definitely. And we have seen that.
Yeah. But times. they are not able to take decisions.
Yeah.
So any outsourcing can be done, but the decision should be done at the level of the board. Of course, I don't think that we should move all factors, everything in Mauritius. If there is investment in India, we will need to have people from India who give their input.
Yeah.
Well, we'll need to have this, but we need to show that ultimately it's the Mauritian directors and they have knowledge of the sector that they are operating.
Yeah.
The companies are operating.
Yes. And that is why perhaps, like I said before, this condition of multiple times, etc., it's in the regulations, but something that we should have certain conditions already here so that we understand that there shouldn't be rubber stamping. And when you talk about the responsibilities of the directors as well, as you have said, there's personal responsibility, and we have seen that many times. And those responsibilities should be in respect of taking decisions, questioning what is happening, and hopefully, I think there need to be dialogue to be able to get there, to be able to reach that, because I don't know if we are there yet. I'm looking at Afzar here. I don't know if we would be able to, because when we talk about the directors, then it is definitely think about how we would be able to create this kind of autonomy, while at the same time they will consult people who could know about certain investments, etc. But finally, the decision rests on the Mauritian company. Pramod,
if I may just add a small sentence, I'm probably going to be told off for saying that, but I think we need to stop thinking about how can we use this to make money for our company. I think we need to see this as how can we use this to elevate our country. Yeah. I don't think I've been back to Mauritius for the past 12 years. What I've seen is, unfortunately, how can we increase our P&L for the next 2-3 years? We need to snap out of that mindset.
Yes.
Very difficult.
Pramod, can you hear us? Are you here? Yes, I think
thank you so much.
Okay. Pramod,
yes.
We have, maybe you would have, before we dive into the next question, perhaps if you have a few comments on what we have just discussed.
Sure. First of all, I must compliment each one of you for such a pragmatic and thoughtful approach to the whole issue. I mean, it's really a privilege to be with you all and to see such a clear discussion about the real issues. You are introspecting, you're asking larger questions. That's absolutely amazing. Secondly, the point which Rayan made about on what basis was the protection declined in this case was with respect to the indirect transfer. Am I right, Rayan? That's what you asked?
Yes, indirect transfer, but then we can talk about the indirect transfer as well.
Just one sentence. Yeah, we will come to that little later. Just one sentence on that. Please remember, Rayan, what was the plea of the Tiger Global in this case? They specifically invoked 13.3a. 13.3 talks about direct investment, and it was very easy for the other council to show that you are not covered by 13.3a. So, and now the other point which you have made with respect to substance, I think that's particularly fascinating. And I would say that substance is not only required in the individual taxpayers, but also in the jurisdiction as a whole. Now, please consider an example like Ireland. Ireland does not produce aircraft. But Ireland is a major aircraft leasing center. So if you are able to establish yourself as a major international financial services hub, then I think that is the most critical part. Once you do that, then everything else falls in place. And if you continue to be, as Afsar very rightly pointed out, as something kind of low value service, then I mean we are living in denial. World has changed right from the time that we heard President Obama's first election is his first term election speech when he talked about the Cayman Island building, which is either biggest building in the world or biggest scam in the world. From then on, agenda was clear. Then Indian Prime Minister, it was not a question of the Mauritius alone. Our Prime Minister from the Independence Day speech, he talked about shell companies in Kolkata. So today we have to live with we have to reconcile to the reality. Then the era of those kind of tax shelters, which are wholly contrived tax shelters, that era is over. Yeah. And I mean, we have to build a particular jurisdiction for substance in that area. That is the key. And I would entirely agree with Afsar on that point.
Yes, I agree, Pramod. I think. But then, Pramod, maybe you can help us understand about. We have talked about effective management. We have talked about commercial substance, and as we have said, in Mauritius, we have the concept of central management and control. There has been mention in the judgment about the head and brain being in Mauritius, and it didn't come from the conclusion reached by the Supreme Court, but it has been mentioned, and we have been seeing this. Everywhere recently. So maybe if you could explain and provide some more information on whether it is something to be considered.
Now, this concept of head and brain test, it is not part of the operative judgment. As a matter of fact, if you really look at this test, there's a mention about this expression at 6 places. And all these 6 places are either the proceedings before the lower authorities, or before the authority for advance ruling, or the arguments of the revenue. So head and brain test is not something which is defined. I don't see any reference to this in this terminology so far as Indian jurisprudence is concerned, yet it's being talked about because this is an expression often used in the debates about this decision. The head and brain test has been talked about in the authority for advance ruling decision, but that again is not the part of the decision. Now, if head and brain test means that you should have no outside intervention, that is something totally alien to the way the corporate structures work. If you have a parent company elsewhere, they will have a say in this. So head and brain test would, if you are viewing it from that perspective, that's not what is something which is acceptable in the scheme of the international taxation or these cross-border entities. But if you really mean that everything which is decided is done outside, and what is in the particular jurisdiction in which the residence is claimed, it's only an empty formality, then certainly yes, that would not meet the residence test. And as the panelists have very rightly pointed out, you have to realize that in case the activity which is being carried out in the jurisdiction of which you claim to be resident is purely formal or purely procedural or kind of a formality being completed, obviously it will not entitle you to the residential status. You need to have effective management situated in the country. That does not mean on one extreme that everything should be done on your own without any reference to the parent companies, but that does not also mean that you can do just a formality of having the audited accounts and having directors who are directors of 900 other companies and claiming that you are effectively managed from there. So you have to find that balance.
Yes, understood. We will come to you again, Pramod, on GAR. Before we talk about the GAR provision application on the judgment from an Indian perspective, perhaps we will move to Iqbal to understand from a Mauritius perspective, given that we have a lot of offshore clients who are our viewers right now. And there has always been the comfort that there is the investments prior to 1st of April 2017, they are grandfathered. And there's the protection that you're supposed to get the exemption from the capital gains, etc. So how do we interpret it to ensure that investments before that cutoff date remain protected from a Mauritius perspective before we move to to Pramod for an update from an Indian perspective.
That's a deadly question. Very important for everyone, but at the same time frightening in the implications. The thing is that we cannot, even God cannot rewrite history. What is done is done. Those companies are here, and they've done and they've structured themselves in a way which is particular to the period in which they were set up. Mm. Now, the problem is that, as I understand this judgment, the assessment officer, if he has a prima facie case that this is a pure conduit company, he can open up the investigation about the structure, and that can move on to the various other facets of the examination that we have seen, and therefore declare that this one is unacceptable, how do you call it?
They make it, if I may, they make a distinction between an investment and an arrangement.
Yeah.
It's no longer an investment, it becomes an arrangement.
That's right.
Yeah.
That's right.
Yeah.
And arrangement is much wider than investment. It involves the structures. So the structures are there, and if that approach is gains weight, then the question is immediate.
Yeah.
Any company who is likely to be either divesting from India or there's a transfer of shares need to be worried. So there's a sudden uncertainty, immediate uncertainty in the air, which we need to address, and that's beyond us. That's beyond the companies. That's beyond except the government officials.
Yes.
I think this is a prime case for an urgent conversation between the Mauritius tax authorities and the Indian tax authorities to provide some guidance. How do we deal with that? Now, the funny thing about it is that it should not have had the importance that it is having today, because the GAR, as it is looked at and as it is dealt with, is simply a prolongation of all those cases we have known in our student days, from, Duke of Westminster onward to the recent cases that we have seen in UK, Gobble Kane and so on. So it's just, there is this explanation in the judgment about the statutory GAR, which is as it is written in the statute, and the judicial anti-avoidance rule, the JAR. So you've got the GAR, you've got the SAR, and you've got the JAR. Now it's a question into whose teeth you want to get into. The problem that we are facing is that I think that the way the assessment officer and the judgment goes about it is the threshold that is adopted to go into that examination. That is the big danger. I think that the threshold normally should have been where there is a suspicion and a high suspicion on top of that on evidence for which the tax authorities bears the onus of demonstrating that there is an almost like a fraud on the tax legislation, or an abuse of the tax legislation. Whereas here, we are looking at very pure formalistic way, which is missing. So to me, there's a discrepancy in there. If we put it at this formalistic level, if you don't have it, then you are suspicious. Is to me to put the threshold very low, and therefore exposed a lot of companies to unnecessary examination. And that is why, to close that gap, it is quite urgent that the Mauritian authorities picked up the opportunity to have a conversation with their colleagues in India and try to settle on some form of basic criteria with which the existing companies in Mauritius would abide by. I mean, that's, I think, a primary urgency that we need to care about.
Yes, agreed. And then Pramod, if can you hear me?
Yeah.
Based on what Iqbal has just said, there is a lot of uncertainty. You will agree, based on the application of GAR in the judgment of Tiger Global. Can you provide your perspective on how this is viewed?
First of all, I agree with what Iqbal has said. This is a serious issue, and there is an arbiter which does give rise to legitimate apprehensions of the taxpayers. Please understand what is the guard protection given in the rules. First of all, it is given in the income tax rules, which are part of the delegated legislation. Central Board of Direct Taxes does it. Please also understand that there is no official word on the scope of this as yet now. What is argued in the courtrooms, what is the stand taken by the legal team, is not necessarily the same stand which is taken by the bureaucrats who are taking policy decisions. We have to understand sometimes there's a distinction between these two stages. Now, what is the rule? Rule is that if you have made investments prior to 1st April 2017, these investments will be protected from the application of GAR. That is rule 1. Technically, it is rule 10U1D. The other rule is, and that rule is, without prejudice to the first rule, that is 10U1D, any arrangements, irrespective of when they are created, will be covered by GAR. The way it is understood, and the way I understand it, and the way most of us understand is, if I have made investments prior to the cutoff date, my investments are protected by GAR, stand protected against GAR examination. But if a structure is in place, the arrangement word, let's substitute by structure for a minute. If there's an arrangement in place which is in existence prior to 1st April 2017, that will not be protected. I cannot turn to the income tax department and say, look, this company was in place even before 1st April 2017, therefore you cannot destroy. Now, the distinction between investment and arrangement was traditionally seen in this way. That's how I understand it. That's how most of the people understand it. That's how Philip Baker, as I heard him in one of the IFA webinars, he understands it. But the way it was argued in the courtroom was, no, if it's a tainted arrangement, then if it's a kind of a abusive arrangement or something which can hit the GAR, then it will not be treated as an investment, it will become an arrangement. That argument, to my mind, is fallacious. You are not entering the main building, but you are entering the bedroom. If you don't enter the GAR itself, where is the question of examining whether it fails the GAR test? So to that extent, I would think it may be an observation which would affect Tiger Global, because a judgment of Supreme Court is final between the parties. But that is certainly, it cannot be final so far as development of law is concerned. I'm sure this is one part of the judgment which will probably need to be revisited at some stage. And I'm also sure that the Central Board of Direct Taxes in India will also come up with an adequate a clarification on what is their official position. Remember, the words used in Rule 2, this is Rule 10U2, is without prejudice to the first rule, that is 10U1D. So without prejudice to means I would protect that. But the way it is written is, I will dilute it. As a matter of fact, court has used the words, they have used the expression, Rule 10U2 dilutes Rule 10U1D. I do not think it dilutes, it protects. So to this extent, I'm with Iqbal that this is a cause of concern. I'm also with him that is not a reasonable interpretation. That judgment of the Supreme Court, but it's an arbiter and it's a judgment, it's a final thing, even if it's taken as final part of the ratio. That is, so far as Tiger Global is concerned, I would still think that is a question which is a very valid question, valid apprehension, and it needs to be addressed, ideally through the administrative mechanism, and I'm sure it will be addressed. One of the biggest strengths of the present establishment in India is they have ears to the ground and they are ready to take what is required to be done, take action which is required to be taken. So I would think there's no reason to panic, wait for some time, a suitable clarification should come in this area. Okay.
I think it is a bit of worry for investors, definitely, because we are saying that it is grandfathered, but the benefits have been derived after, so the grandfathering is not applied in that case. GAR provisions come into play if it is seen as a sham or a conduit or not enough commercial substance. So hopefully we will
You can't put the tests of GAR if you are saying it will not be subject to review by GAR. When you are protecting it from the GAR, then you will not put the GAR tests. So there seems to be some incongruity in the argument which has remained undetected, which has been not approved, I would say, which finds observation in by way of arbiter. But that's something where clarification could possibly come. We should wait for some time. And as you say, you have taken up at the government level, so that should all be all the more reason on clarity on this. But don't forget that this situation has arisen because of a peculiar argument, which is ununderstandable to me. I mean, I don't understand. How do you say that I'm covered by 13(3)(a) protection because I made an investment? It's beyond my understanding.
Okay. Afsa, maybe you have something to add?
One observation. Since the Tiger court case, there's been a lot of arguments brought forward mainly by professionals. A lot of professionals, we are talking about uncertainty, we are talking about lack of clarity. But where are the investors?
Oh, they ask questions.
Where?
To me, a lot of people are.
Where are they asking the question? The stock market is doing well. The budget has come and well acclaimed. Foreign investors are still queuing up to go to India. Who is complaining?
India has lost about $3 billion over the last 2 years or so. Outflow of fund is redemption by FIIs. So it's a new world, I mean, altogether. Let's face it. In fact, when we're talking about substance and so on, we have a difficulty. It's not substance simply.
Yes.
It's about the new way. This is where I come back to where I started. A new way by which we see how capital nations that have got we are full of capital and capital-hungry countries. This flow, which used to be well organized since the First World War I. Don't forget, Luxembourg had its first offshore company, Sopafi, in 1923. Jersey, Guernsey, and so on came after the Second World War precisely for that purpose of transferring capital from one country into another. That's the least cost. Yep. Now, this system has broken down. Countries are likely to eliminate the intermediaries. So unless you come with the full value added to the transaction, you are out of the game, I think, in the next 5 to 10 years. Okay. That's the problem. So that's why we are late. Can we catch that up in the next 2, 3, 4, 5 years? And in that new landscape, we would not be able to be a new Ireland or a new Luxembourg. We cannot even be a new Kenya. I mean, just put it the other way around. What is it that we can quickly build on? Yes. So I'm probably digressing.
No, that's fine. That's fine. In fact, you're going to my next question because I think we are short on time, so we will need to rush a little bit on the questions. But we already went through all the different aspects of substance, commercial substance, etc. And now we want to come more to the practical aspect for investors and structuring. Many of what I'm about to ask, perhaps we already talked about it a little bit. So I will turn to Joanne to the anti-abuse measures that we have seen and how it erodes now the negotiated treaty protection that we already have, warranting regulatory, diplomatic or policy engagement.
Yes, so I think Pramod and
they already replied a little bit.
Touched on that a little bit, but
yeah.
I think one comment I'd like to make, and this is something that it's easy for me to say, sat in Eben behind my comfortable computer, but I know it's easier said than done. But one of the things that we have noticed, I'm sure Ryan will agree with me, over the last 10 years is every time there's a change in the law, whether it's tax or legal, we feel that people aren't talking to each other. So sometimes it feels like tax is driving policy when it should be the other way around.
Yeah.
Sometimes we put together a framework. I'll just take the example of the VETOS Act, for example. We want to promote Mauritius as a fintech hub, and the tax wasn't following. There's no appetite from financial services market. So to go back to Tiger Global, I think that, yes, it's important that the tax authorities or even using diplomatic channels to talk to each other. But more importantly, all aspects of the ecosystem need to sit together in one room and speak to each other so that the value proposition doesn't only benefit one area.
Yes.
We're putting fair share contribution. On the other hand, everyone else is leaving. So it needs to be one holistic vision. And again, I'm going to be told off for that, but I went to Singapore a month ago and I just thought, what are we doing? What are we doing? And maybe it's unfair because I don't think it's unfair, actually. We probably started around the same time when we got our independence. But I think when we're talking about diplomatic engagement, legal engagement, financial services engagement, tax engagement, and the industry, obviously, it needs to be one holistic value proposition and build the ecosystem. We talk time and time again about what is the point of putting incentives and legal framework together when we are not focusing on education, infrastructure,
Yes.
attracting people to Mauritius, moving families to Mauritius, getting rid of that protectionist mindset. So yes, it's a tall order, and as I said, I know it's easier said than done, but I don't think it's something that needs to be seen as there are low-hanging fruits. I'm sure there are quick fixes, but we need to look at the longer-term vision.
Yes. Okay. Afsa, from a practical perspective, you do a lot of mergers and acquisitions, etc. All these kinds of dealings, valuations, exit planning. What would be your advice to those investors? What should they consider when they are exiting or planning cross-border exits in terms of after the Tiger Global?
I mean, I think the rules haven't changed. You always have to look at the reason why you are entering a business. Mm-hmm. You're not entering a business to exit.
Yeah.
Unless you are a private equity fund where you have a timeline, you want to exit. Then if that's the case, you start looking at your post-tax return. Otherwise, if you're going into India, you look at the prospects, you look at the business, you look at the targets, and obviously you try to enter at the right price.
Yeah.
The impact of Tiger Global may adjust some of the valuation which we have seen recently in India. We may have to see a bit more realistic valuation, where things could be a lot easier for investors to get in if there's going to be a big tax outlay on the exit. But usually the logic of investing should be the same.
Yes.
And the prospects that India offer haven't changed. Mm-hmm. It's the approach that needs to change. Okay. Because if you go back to the case, it does not tell you the tax treaty benefits are not available. It just tells you to change your approach if you are going through structures, otherwise come direct. So the prospects still remain. It's just the approach that needs to change.
And definitely everything which comes with how we are managing the companies, the IFC, etc.
Exactly.
Okay. Pramod, I will not, just to give some more understanding to investors mainly about the indirect share transfer. If you could help us understand, because we are saying on one side, in fact, the Indian authorities are saying on one side that the underlying assets are in India, so value has been derived there and capital gains tax should apply. And on the other hand, we are saying that it is an indirect application because the merchant entity sold shares in a Singapore company, and it is an indirect transfer in that case. Would you help us understand that, so that for the investors?
Now, so far as the scheme of the treaty is concerned, residuary rights of taxation are with the resident jurisdiction. So Mauritian companies having a capital gain which is not covered by any of these specific clauses, this can only be taxed in Mauritius. Now, capital gains on indirect transfers are taxable in India because of the peculiarity of the Indian domestic law, right? And to that extent, it falls in the residuary head. This should be available. And there is no problem about it because any income which arises in India to a company which is resident in Mauritius would fall in one of the distributive articles. And it will be dealt with by one of the distributive articles, the relevant distributive article, Article 13. Article 13 says anything other than 1, 13.1, 13.2, 13.3a gets taxed only in Mauritius. So there is no reason to worry. You are home so far as the multi-layer instrument, so far as third country transfers are concerned. But as I repeated several times, the plea in Tiger Global was a unique plea. They were not saying we are in clause 13.4. They said we are covered by the exclusion embedded in 13.3a. That is where the problem is. So the observations which are made by the court should be seen in this light. I would not think that it is anybody's case that if you are not claiming an exemption, a protection of 13.3a, and you are not falling in any of the categories, then also you are to be denied treaty protection. So I would think, as far as the legal position today is concerned, it's quite clear. Any income, any capital gain which is not covered by 1, which deals with the movable property, 2, which deals with the PE property, 3a, which talks about the shares in a company which is resident in India. 3a, you are not covered, then you are not taxable. So it's quite simple. However, because in the public debate, in the arguments, and sometimes some overzealous people who have been associated with the legal team and from one side or the other, they present a perspective which they believed was right, and that has come in public domain. There is some concern. That concern, to my mind, is not a legitimate concern. Indirect transfers continue to be treaty protected, and if there is any ambiguity about it, you will recall that in 2012, when Expansion 5 to Section 911 was introduced, the then Finance Minister on the floor of the House, Parliament, said that these provisions do not affect any of the treaties and the impact is confined to the transactions which are with the non-treaty partner jurisdiction. That statement has not yet been withdrawn. There is no amendment in the treaty, so I would think it stands good. Indirect transfers are safe. There is some confusion because of this legal development and some auditors. There may be short-term problems, but I don't think there is much to bother about in the long run.
Okay, that's good to know. As we are running out of time, so I would prefer that if each one of the panelists could say a concluding word and whether you can provide some recommendations on what the respective governments can do to issue clearer guidance, etc. I will start with Iqbal.
I think I've said my take on it already, but I think I'm just thinking that our focus is because of this judgment comes from an Indian court.
Yeah.
But what we're talking about, the sector in Mauritius, should perhaps widen the purview to look at Mauritius as an IFC, which is not limited to India.
Yeah.
First thing. Second thing is that it's waste of time to cry over the spilt milk. What is in the past is in the past. Let's look towards the future. The future is a different shape, and we need to be able to identify where the opportunities are and focus on that. Don't forget, since 1992, the framework of the global business has stayed the same. That is more than 30 years. Is that sustainable?
Yes.
It's wobbly
Definitely.
now. I mean, it's clearly wobbling.
Yeah.
So it's about time we do something
Of course.
to revamp the whole structure of the financial services in Mauritius.
Yes. Agreed. And Ryan?
Yeah, I think I will go the same line as Iqbal. The world has changed, so we'll need to adapt. We'll need to adapt, and for new structures that we want to attract, we'll need to have something special to offer. Like Pramod said about Ireland, they have something specific to offer in terms of aircraft leasing, I think. We need to find what we are good at. But also now let's not forget as well the existing investment. So for that, maybe what could be done, because for me, taxpayers, investors, they are not afraid to pay tax. What they don't like is uncertainty. Maybe there could be an agreement between Mauritius and India to what are the conditions, what are the minimum requirement that India would accept, safe harbors that they would accept to not dispute the TRC. The conditions of the TRC need to be agreed between the two parties. I know that in around 2014, there were discussions between the two parties. There were even drafts that were circulating among professionals on what India was proposing.
Yes.
Maybe if we can agree on something, then this will provide certainty for existing investors.
Which is very important.
Yeah.
Joanne, a final word?
I was just thinking about something someone said to me last week. I don't think I'll be as harsh as that. They said that something along the lines of we need to burn everything to the ground and start building again. Probably not as drastic as that, but I think we need to find our blue ocean. I think we've been in the red ocean for a while, and we're being circled by sharks and comfortably ignoring them, but I don't think it's possible anymore. Someone said to me recently, and I think we've been talking about that for years, about making Mauritius a regional shipping hub. I don't know what we're waiting for. It takes years to register a ship apparently in Mauritius, but anyway, that's just one idea.
Yeah. Afsal?
Well, I think I'll quote Salman Khan. Tiger Zinda hai, and he's here to stay with us. So, so we might as well raise our game. And I think it's a great opportunity to rethink, reconsider.
Yeah.
We are in the office of Rogers Capital. I just use Rogers as an example. If Rogers goes and buy a company in India tomorrow, how much you guys as tax expert will be involved? I don't think you will be involved. It's a fairly straightforward, and all the tax benefits will accrue to Rogers within the law. Why can't we repeat the same thing with other investors coming from Mauritius going to India? Let's use the same thing. Like I said earlier, we need to attract investors, get them to buy their offices, bring their management, bring their families, and it's all integrated with all the aspects of the Mauritian economy so that financial services is not restricted to just global business.
Yeah.
Thank you.
And Pramod, a final word from you before we end?
Yeah, I agree with Afsar. Tiger Zinda hai, but he has to change with the times. If you are thinking or anybody thinks that a treaty benefit alone can be reason enough for somebody to come to Mauritius and he will be entitled to the treaty benefit, no, that is history. That's over. But as our Prime Minister says, every crisis has an opportunity. Aapada mein avsar hai. So now this is your opportunity to ensure that the jurisdiction develops as a jurisdiction conducive for the international financial centers. And people also bring in substance. These companies are effectively management. Irish example, which Rayan referred to, I think that's perfect. I would also think that there is no reason to panic by some of the observations in the judgment. These are in a particular context, and one must see those observations only in those contexts. Yes, there are problems with respect to grandfathering, etc., with respect to GAR. A few things need to be set right. Have faith in the Indian judicial system. It might take a little while, but those aberrations will be neutralized in the times to come. It's only a matter of time. And I would also think that the clarification should ideally come from the bureaucracy, which should be in the offing. So no reason to get panicky as long as you are effectively managed from Mauritius. You are ready to change with the changing times. Things are good, and for the small little hiccups, this too shall pass.
I think the panelists have rightly summarized the discussion that we had today. One ending conclusion that I would have from my side is that everything we have discussed right now from a Tiger Global perspective, it's not an issue only for Mauritius as an IFC. It is for all IFCs. And Pramod has shared a judgment which has happened last week with us, which is very interesting because that's by illustration. It is good that we understand. It is called Harian Solar Singapore Private Limited, a ruling which was by the Income Tax Appellate Tribunal. And there it was seen that the Singapore company was a conduit company, and the TRC issued by Singapore was denied. But that was done not under GAR that time, but it was done under the LOB clause of the India-Singapore Treaty. So as a conclusion, we have to see it is not only about Mauritius as an IFC, it is about all the IFCs that we need to look at the Tiger Global case and learn the implications and what to do going forward. Thank you. Thank you to the panelists.
Very much.
Thank you.
Thank you.
Thank you very much.
Pramod.
It was a pleasure to be with you.
Thank you.
Thank you.
Thank
Bye.
you.